Hi everyone, you're watching the Virtual Amicus and I'm Jay Ludha. So today's topic for discussion is on usage of algorithm in digital markets, an anti-competitive concern, and a brief overview of LLM in competition law. Now this is something really very unique. Just to give you all a brief background about what competition law is, it was triggered by Articles 38 and 39 of the Constitution of India. These articles are a basic part of our constitution that talk about directive principles of state policy. Now, based on these directive principles, the first Indian competition law was enacted in the year 1969, which was labeled as the Monopolies and Restrictive Trade Practices Act of 1969, which is also called as the MRTP Act. Now, one of the main aims or goals of this act or this legislation was to encourage fair play and fair deal in the market besides promoting healthy competition. Subsequently, it became obsolete in the light of these international economic developments, the liberalization, globalization that happened, the 91 reforms relating to competition laws, and hence focus was shifted from curbing these monopolies to promoting competition in our country. This gave birth to what we call as the Competition Act 2002. So it was basically enacted to fill these gaps, these loopholes that were left open by the MRTP Act. And that certain offending trade practices that it deals with, such as abuse of dominance, cartels, bid rigging, collusive agreements, price fixing, predator pricing, etc. Now, today's topic for the discussion is on usage of algorithms in digital market from the aspect of competition law. So today we decide to seek assistance from a very passionate, very articulate young lawyer from Jodhpur, which also happens to be our principal seat. We are joined by Mr. Mehul Kothari. And just to give you all a brief introduction about our amicus for today's session, Mr. Mehul Kothari is currently working in the chambers of Kothari and Associates at Honorable Rajasthan High Court. He pursued his law from Jindal Global Law School, NCR, Delhi, back in 2017. He subsequently did his master's LLM at University of Haifa, Israel, Erasmus University, Netherlands, and University of Vienna, Austria, in the Emily program from 2008 to 2009. So 3 universities, 1 program. We'll come to this later. How is it possible? And he previously worked, as far as work experience is concerned, as an associate with AZB and partners at Bangalore from 2017 to 18. He's also worked in the esteemed chambers of Sri Vinod Sharma and Associates at Rajasthan High Court, Jodhpur and Trial Court from 2019 to 2020, and also in the chambers of Sri Manoj Bhandari and Associates at Honorable Rajasthan High Court, Jodhpur bench. So thank you so much, Mr. Mehul Kothari there. And the topic is very interesting. We can't wait to start with our segment. So I think the stage is set. The floor is all yours. Over to you.
Thanks a lot, Jeff, for having me over on this platform. So to start off, I'll give a brief background about the kind of LLM and the kind of exposure this LLM provides to any student who wishes to pursue this course. So the program is called European Masters in Law and Economics. The name itself shows that it's an interdisciplinary course. The main objective of this course is to show as to how law can be seen from an economic efficient viewpoint. There are 10 universities associated with this program. 8 of those said universities are European universities and 2 are non-European universities. And there are 30 different nationality students. So culturally, diaspora is very rich. You get to interact with different students from different countries, different perspectives, all of them coming together at this one place. The program starts in October each year. So it's a fall semester beginning program. And the duration of the program is again the same as any other LLM. It's 1-year course. The good thing about this program is, as all the other programs, the issue that arises is the tuition fee. So in this program, the tuition fee is not considerably very reasonable considering the other programs that are being offered. The tuition fee in this program is 10,500 euros. Again, which is exclusive of living expenses that you're going to incur there, and also exclusive of the fact that you're going to travel around all of Europe and also the non-European countries, which one is Israel and the other is India, Bombay. So another interesting fact about this program is that once you are at each term meaning each university that you go to, you get a separate degree from that university. So at the end, instead of having 1 degree, you have 3 degrees from each university that you've been to. So the program is run in a manner that you have a choice of picking 3 different tracks. Tracks is basically your specialization in subjects. So the 3 different tracks that you have is the public track, which focuses on the public law aspects. Then it's a MCR track, which means markets, cooperator, and regulator track. And then an IP, which is intellectual property tracks. So all these three tracks have their universities associated with the program. I picked the MCR track, in which my terms were Haifa, which is Israel, University of Haifa, then Rotterdam, Netherlands, Erasmus University, and Austria, University of Vienna. In each of these terms, I got to spend almost 4 months going through different courses. In overall, over the course of 1 year, I had to cover 60 credits, 60 ECTS. So the purpose of law in economics, why it's necessary to understand and how these interdisciplinary courses interact with each other, where it makes you understand from a positive economic analysis as to what the behavior of a legislator is, or a prosecutor, or a judge, or a bureaucrat, the model of rational choice, which underlines much of modern economics, supply and demand, and cost benefit analysis of any decision that one makes, proves to be very useful in explaining how people act under various legal constraints. So, as I've already explained to you, there are three tracks in this program, and there are three terms that follow. While the first term, the courses are the same across all tracks and universities, specialization in subjects start in the second term, with two specialized courses in each track and three courses that will be taught similarly in on all the universities that are part of this program. Then the third term, you finally get to choose according to the specialization you want to pick, with two courses that are unique to the chosen track and university. And then the final is the thesis that you write under the instructions of your supervisor that you pick from your third track. So that's overall an overview of how the university runs its program, and it's also funded by the European Union. So that's to give you a brief overview of what and how the university and the program is run. Now, to just fill in some of the gaps that Jay was talking about and give you a brief overview as to what competition law is, why it was enacted, and why the erstwhile Monopolistic Restricted Trade Practices Act 1969 was repealed. So, as Jay rightly pointed out, the enactment of the MRTP Act was based on the socio-economic policies enshrined as in the Directive Principles of State Policy. The Act went through subsequent amendments in the year 1974, 1980, 1982, 84, 86, 88, and 1991. Due to the change in business methods and allied activities during these periods, and also the liberalization globalization policy, which came into effect in 1991, people started to feel that the MRTP Act was becoming obsolete. I was not adequately equipped to tackle the competition aspects that were coming into picture. Because of globalization, a lot of domestic and global players started to compete in the market. So the practices and the acts, the provisions written in the act were kind of becoming obsolete. So then there was a need to shift focus from curbing monopolies to encouraging competition in the market, and to make sure investment and growth takes place. Therefore, needing to promote competition while ensuring that abuse of dominant position does not happen. Then what happened is, subsequently in October 1999, a high-level committee of parliament was appointed under the chairmanship of one Mr. S.V.S. Raghavan, who at that time was one of the main tycoon Indian industrialists, to suggest a modern competition to take into line and take into account the new international developments that were happening at that period in 1991, and make sure to how align those activities to the Indian economic conditions. Then the commission recommended an enactment of a new competition act, which is now the Competition Act 2002, and also established a competition authority, which is the Competition Commission of India. The essence of competition, as defined as act of sellers individually seeking to acquire the patronage of buyers in order to achieve profits or market share. The Competition Act was enacted by the Parliament of India and came into existence in January 2003. So the three salient features of Competition Act 2002 provides for establishment of CCI, which is a quasi-judicial body, and has all the powers of the civil court of gathering evidence. So the three major elements that are covered in the Competition Act, as Jay has already pointed out, is one, that they have to try and curb anti-competitive agreements being signed between market players. Second, abuse of dominant position. And third, combinations, which is regarding M&As. So all these three are defined in the Act under separate provisions, Section 3, 4, and 5 and 6 respectively. So CCI's role is to observe and make sure and ensure and prevent practices that have an adverse impact on competition in any manner and promote and sustain competition in the market. They have to also protect consumer interests at large and ensure freedom of trade carried on by other participants, all the other participants in the market, and look into matters which are connected or incidental thereto. So the jurisdiction of CCI, so how anyone, if anyone has a complaint, they can register an inquiry or complaint with the CCI, and then CCI bench would accordingly take actions within the local limits of its jurisdictions, and the respondent's voluntary resides and carries on. So any person can file a complaint, and within the local jurisdiction of CCI, it will accordingly take cognizance of that complaint and proceed to investigate the matter if a prima facie case is established of and they feel that there is any anti-incompetitive agreement being signed or any abuse of dominant position happening. CCI then will direct, so there is a director general position in the CCI. He'll be directed to investigate the matter further to make sure whether any of these things are taking place. So that's to give you a brief overview of the CCI and what the Competition Act entails. There are a lot many other details that I wouldn't be covering in this session, and we'll be having a special session for that to cover all the nitty-gritties of the Act. And in that session we'll be discussing further as to what and how Competition Act of 2002 covers and ensures fair market play. So to talk a little bit more about my thesis, the thesis topic is usage of algorithms in digital market and an anti-incompetitive concern. So if we see that generally markets compared to a brick and mortar store are now being run on smart applications. All these smart applications are backed by a functioning of an algorithm. How these algorithms process data, how these algorithms run. So a smart application would run on an operation of algorithm, which has multiple decisions leading up to the interface of that particular application, which is preference of product, the price of that product, numerous brands, and other numerous decisions that have to be taken. So to understand this, it would be first appropriate to understand what an algorithm is. So an algorithm is any coded program which contains a computational structure to perform specific tasks. For instance, let's say Uber. So algorithms are set in Uber. So the application of Uber is run by a set of algorithms, which make sure that dynamic pricing takes place when there is a supply of drivers and demand of consumers is more than supply of drivers is less. Then dynamic pricing would charge a surcharge to each customer that is using Uber at that time. So digital markets like Uber, Flipkart, Amazon are reaching their true potential with the usage of algorithms and the ability of an algorithm to process information. It enables efficient functioning of digital market. Now, say for example, if you're in a brick and mortar store, we go to the store person, the salesperson sells us a product. It takes sufficient amount of time to process all those details while he's putting down the details of the product that we bought. Now, similarly, if we are sitting at home in the comfort of our home, we order something on Amazon. It's very easy that you go select the product, you say put add to cart, you go to add to cart, you say place your order. So the ability to process that information gets shortened with it happens within seconds. You can process that information within seconds and place your order for whatever product you want to buy. So we need to start to understand how dependent we are becoming on these platforms, be it to accessing an ATM or searching online for any information, reserving a table at a restaurant, booking tickets. All these things are being run on applications which are being in the background running on an algorithm. So say now we are on a Google search. Google employs algorithms to draw whatever relevant information that we search. So when we go on a Google page, we put in search phases. the algorithm feeds off the information that we feed it in it, inputs that data, runs it against the available web pages it has access to, keeping in mind the user history, the location of the user, where the search query was generated, and will show you the relevant results to the user. It is frightening that the amount of data these algorithms can process and store in servers to relevance to its each user. So the use of algorithms is going to grow as the consumer's economy transitions to an algorithm-enabled products, be it AI-enabled refrigerators, be it AI-enabled home speakers, or smartphones, or smart cars. Algorithms are slowly advancing in its manner of development. They're capable of learning on the job through the past experiences, constantly adapting by engaging in experiments, involving without any human intervention. And hence, monitoring such behavior will get complicated for any competition agency. The digital advancements have helped in creating such digital artificial butlers capable of carrying out tasks to perfection. Take, for example, Apple's assistant Siri, or Microsoft's assistant Cortana, or Amazon's assistant Alexa. How these AI enabled assistants are able to carry out their tasks to perfection without any human involvement other than the feeding of information that you give to them. So there are two types of algorithms. One is the machine learning algorithm, and one is a deep learning algorithm. So machine learning algorithms are function without any human intervention to produce results by feeding queries through a structured program. Whereas deep learning algorithms interpret queries through a multi-layered neural network, something exactly like our brains, and identifies the inaccuracies itself and provides solutions accordingly. So we need to start realizing that obviously algorithms are significantly reducing the time and effort it is taking to process data in comparison to a human brain. So algorithms are all obviously a valuable tool in today's digital market, and consumer is merely being seen as data to be collected, analyzed, and that related information is relayed back into the market. So any activating where there is a digital trace being created, it is leaving a data footprint behind. And algorithms are having sufficient tools to analyze that data, create patterns, and form which they gather into uh, tracking down customers' preferences and user history data, and then creating patterns and search results for you. So an example for Netflix, the algorithm that when you go on the Netflix user face interface, the algorithm reflects against each TV show or each movie a percentage mass based on your viewer history as to how much you might like that show or might not like that show. So slowly, the algorithms are able to predict a pattern of behavior of human behavior and suggest accordingly as to what a human might like or might not like. So similarly, if these algorithms are able to do this, we can also assume, and it's already happening, that these algorithms can set and fix prices on digital platforms like Amazon, Flipkart, by quoting different prices to users on different platforms as a result of the data they have access to. So, say in a situation, there are two sellers of a certain homogeneous product. By homogeneous product, I mean perfect substituted products, say X and Y. And as prices are posted online on all digital platforms, they're aware of each other's pricing. Suppose in this example, there is an algorithm that not only monitors the price of the competitor, but accordingly sets the respective product's price. So this way, the algorithm would function as it is would raise the price of one product, and similarly, the other product would change. In case a change in price is not made, in response, the seller of one product will start to decrease the price and undercut the other person. So the algorithm would keep repeating this process of raising and lowering the prices. After few rounds of such raising and lowering of prices, other manufacturer would realize this irregularity in the behavior and then interpret this as a signal to raise the price and reap the long-term benefits or suffer financial loss due to undercutting of price. So we need to understand if both firms, in this case, if both the manufacturers X and Y employ the services of the same third-party algorithm to monitor the price on their platform, which in turn becomes platform for price manipulation by the algorithm. There is one more example of Amazon. So Amazon in its platform offers a match low price concept to all third-party sellers on its platform. This means that sellers have to match the lowest price offered by competitors elsewhere, which allows Amazon to choose which competitors to match based on the listing conditions of product customer feedback rating and handling time and all those other services. It will decide as to how to match each competitor's price on its platform. So there is an illustrative example of this where there were two different sellers, and you can reference it on Google, where if you put in the search phrase the making of a fly, the genetics of an animal design on Amazon, and you would see that there was a pricing algorithm which was set on these books, and by basing the price of the book dependent on each other's price, both the sellers set it on dependent on each other's price. This created a loop of algorithm pricing. The escalation in price went on for a week and a half, and finally some user noticed that, but that was not before that one of the books being sold by one of the sellers was priced at approximately 24 million USD. This example illustrates how algorithms, if left to their own, can behave and let the decision of pricing get out of hand. So how exactly are algorithms creating a risk for collusion? As I said before, the example of that Amazon platform, two sellers selling a book, algorithms are capable of facilitating collusion and coordination to an extent that was not even possible before and not even traceable by human intelligence, because all these platforms do not share the details of algorithms, as they say it's a trade secret. So the use of algorithms in digital market today has increased because of the availability of data online. All user data is available online. So anyone who creates a digital market platform can easily access that data once anyone signs into that digital platform for using those services that platform. So the characteristics of today's market, say compared to a brick and mortar market, is changing constantly. And the behavior of each of these digital platforms in collecting data has both negative and positive implications. Positive being that all the data is already saved in when you go and place an order and subsequent orders on one thing. The negative data is we are not understanding the implications of this data being saved by that said digital platform. So there is certain algorithmic price fixing issues which came to the attention of competition enforcement agencies across the world. So one such case which first came to the attention was in the United States of America, where the issue of algorithmic price fixing took place in 2015, where the accused, one Mr. David Tompkins, had pleaded guilty to artificially fixing price using an algorithm to sell posters on Amazon. So the prevalent use of algorithmic pricing in a digital market is to understand the consumer behavioral patterns as to how a consumer, what kind of a search does he generate, how does he generate that search, what kind of a pattern does that create for him, and benefit from that technology based on the anti-competitive practices. So digital markets employ services of pricing algorithms which ascertain and monitor the price fluctuations, supply and demand of those commodities based on the customer preferences and various other factors. This analysis then provides an edge to that firm in that platform in that relevant market. So algorithms will continue, and they are continuing to re-strategize their coding based on sequence of trial and error experiments. And with significant advances happening every day in the technology segments, it will be very difficult to predict how AI's algorithms function. An example of this, if I may mention, is an AI system called Librettis, which was developed by Carnegie Mellon University researchers. So Librettis was specifically designed for gaming competition and was tested in a heads-up no limit Texas Hold'em poker game tournament. So this system was coded with incomplete information about the game and about also the rules of the game, and was not given any specific instructions as to how to execute a strategy in that particular game. So at a 20-day poker tournament called Brains versus Artificial Intelligence, Librettis decisively defeated four leading professional poker players by employing a three-prong approach that researchers and scholars figured out to counter the human professional gameplay. That is, the Librettis program evolved an overall strategy about the game. Second, it adapted that into the gameplay. Third, it on the day of the tournament started to self learn from and improve from the position of the opponent, because the reason why it had incomplete information is because poker is a game which requires conscious efforts to bluff, negotiate, and play blinds. So proper instructions could not be feeded into the system. But in that 20-day tournament, it was able to self learn, improve from the opponent's play, adapt its strategy, and win and beat four leading poker players. While poker is again a game of cards, the achievement of this AI system should not be understated. AI is on the verge of realizing its true potential, and it will have wide scale implications if used, and will be used in many ways in the future. But we have to regulate this use. So, say Apple, for example, Apple, through its digital advancements, has made many tweaks in its virtual assistant Siri to overcome the difficulties of the lurking background noise or the optimal speech recognition. Apple has integrated the involvement of deep learning algorithms with the assistance of the engineering team of Apple using top down knowledge from the trigger phrase, Hey Siri, has been able to optimize speech recognition. Siri's ability to work in even one of the most challenging environments to carry out tasks efficiently is supposed to is a benchmark being set for AI's ability to learn on the job. The inclusion, the necessary measures that we need to now take, or in my suggestion, should be taken to address the issue of algorithms and collusion is the inclusion of data protection rights in the understanding of consumer welfare. And implying this principle in addressing algorithms and collusion would be beneficial in the long run. It is essential in today's technology advanced markets that consumer welfare is looked at from the perspective of data protection as one of the key elements in competition assessment. The digital economy is now starting to operate on data collection, and that is raising concerns about privacy, and data protection needs to grow in its nuance. The data protection has not traditionally served as an element of competition assessment at all, as competition law is usually used and aimed at safeguarding fair competitive practices, whereas data protection law is aimed at protecting data rights of a consumer. But there needs to be a change in this outlook. Options have to be looked at from the perspective of how personal data can be included in competition enforcement. This approach has already been applied and taken up by the Facebook investigation carried out by the German competition authority called the Bundeskartellamt. This investigation dealt with misleading terms and conditions for acquiring data. According to the findings of this investigation, Facebook holds a dominant position in the market for social networks, and business model of Facebook is acquiring data and personalizing it to enable target advertisements towards the user. While holding a dominant position in such a market and imposing unreasonable terms and conditions infringes the provisions of the German competition law. Similarly, we need to start taking these stances because we need to understand that platforms are processing these data to reflect consumer behavioral patterns and accordingly target consumers for that relevant market through the data that they analyze. So there needs to be a competition shift, shift in the competition assessment paradigm to evaluate the possible algorithmic collusion, as the algorithm is driven now through feeding of data and processing of that set data that it feeds to. So, is our competition act advanced enough to deal with such possible algorithmic collusion? So, the relevant provision that is contained in the section 3 of the act, the bare reading of subclause 1 of the section explicitly prohibits agreements which causes or like to cause an appreciable adverse effect on competition within India. Further, the reading of subclause 3 lays down various conducts by enterprises which may be presumed to cause an adverse effect on competition and be anti-competitive, and gives commission discretion to enforce anti-competitive restraints to curb anti-competitive behavior. So, in my opinion, competition commission has the necessary tools to enforce and curb such behavior, but it needs to take a proactive approach. Only then will it be able to assess such collusion happening and ensure that no consumer in the consumer welfare is harmed in this process. So we definitely understand. In my opinion, I definitely understand that algorithms are affecting markets and it's resulting in price fluctuation and price monitoring and allowing competitors to act aggressively and signal for coordination. So, if a proactive approach is taken by the CCI to curb such indication and coordination between the digital platforms, then collusion and possible algorithmic collusion can be prevented. So the competition enforcement agencies have to amend its purview and scope of investigation and has to include within its ambit the significance of personal data and attach economic value it possesses in today's digital market. Thank you. I would really like to thank Jay for having me on this platform and having me speak on this topic of my thesis. Thanks a lot, Jay.
Thank you so much there, Mr. Mehul Kothari, for your valuable insights on this really very unique subject. Just wish to add something. So,
Yeah.
to my limited understanding on competition law, so there are a group of firms that are engaged in the practice of, say, illicit fixing of prices, and they're called a cartel. So they are guilty
Yeah.
of price rigging. But see, the cartels are defined in the provisions of the act, but where is the term algorithm defined? That's the question. So don't you think that the competition law has to be equipped enough to?
It doesn't define it in the section 2 of the competition act, but section 3 of the act, subclause 1 and subclause 2, because it says any activity which can have an adverse effect on competition, we can read it into that effect and say that if possible algorithmic collusion is happening, then we can say that under section 3 it is not it's not valid, it's illegal. To that extent, it's given the section 3 is given a very wide discretionary power to take it into account, but per se algorithm is not defined in the competition act, but in times to come it will definitely have to be defined, because now that we see all digital platforms function on a based on an algorithm, how they process that data, how they save that data into the servers, because it's really not possible to process so much data for a human mind in such short time. So all these activities are now being carried out by algorithms, be it for Amazon, Flipkart, and the thing is that these platforms, they don't reveal how their algorithms function, because they say it's their trade secret. So okay, again, that's valid to that extent that it's their trade secret and they do not want to disclose it. But the CCI will have to take proactive steps to ensure that consumer welfare is not harmed. And again, that debate will involve involvement of the concept of data protection, because all these concepts are interlined amongst themselves.
Absolutely right. So trade secret not at the cost of welfare of the consumer.
Exactly.
So thank you so much there, Mr. Kothari, once
Thanks a
again.
lot.
And as you mentioned in the course of the presentation, that we'll be joined by another speaker who will be covering
Yes.
the field of how to develop and build a practice in
Correct.
the field of competition law.
Yeah, he's a colleague of mine who was with me in the master's program,
Wow.
and I requested him to do a joint session with me, but because he was tied up with some work, I'll request him, because he was, prior to doing masters, he's worked in the competition commission, so he'll have much more insight as to how the CCI investigates matters, and how and as to what effect those investigations involve and things like that. So I'll definitely request him for some time in August, and we'll have him on this platform.
Definitely. So, thank you so much, there, Mr. Kothari. Once again, I am sure
Thank
this
you.
segment will benefit, if not, it will immensely benefit all our viewers. And our email is already mentioned on the channel. So, if for any queries on any of the fundamentals or concepts, feel free to write to us. We'll be forwarding the same to our keynote speaker or amicus for today's session, Mr. Mehul Kothari. And if you want, you can directly write to him as well. So thank you, Mr. Kothari, once again. Thank you so much,
Thank you.
everybody.
Thank
And
you for having me.
it was a pleasure to be ours. And it's goodbye for now. Thank you.